But welcome to the Charleston County Bar's CLE. This is on Appellate Practice and Procedure. I'm Mary Lee Briggs. I am the CLE Committee Chair. I know it says David Wolf, but I have logged in under David's Zoom account. So I did place in the chat box, if everyone can see it, the link to the Bar's website with the CLE agenda. So the attendees and the panelists should be able to see that in the chat box, the link to the agenda. The program, we have not gotten the course approval number yet. I emailed the CLE Commission again this morning. They have not gotten us that number. So everybody will hopefully get an email tomorrow at the latest with the course approval number. This is a free CLE to all of our CCBA members. If you are unsure about your membership status, please get in touch with Kim Steele. Her email is secretary@charlestoncountybar.org. If you have registered and you are not a CCBA member, you will not get credit for the CLE. I see one thing about the agenda, but I will repost the agenda link in the chat in a few minutes once more people log on. So again, if you are not a CCBA member, please get in touch with Kim Steele at secretary@charlestoncountybar.org. So we are very thankful to the CLE Commission for allowing us to do our CLEs via Zoom. It took us some time to get this approved, and so we would appreciate everybody cooperating with how we have to log everybody's attendance. So the first thing that I need everybody to do is go into the chat box, all of the attendees, and put in your name and your bar number. And please only do it once because we are going in and logging everybody. So again, if you could put your name and your bar number so that we could give you credit for being in the CLE today. We will also print reports from Zoom about your participation. It shows when you logged on and when you logged off to give to the CLE Commission, which we have to do. We also are required to do 2 polls during the CLE, and I will announce when they are going live. They will be in between speakers most likely, and it will only be for the attendees, but you'll have about a minute or two to respond to the poll, and it's just a yes or no, are you still watching question. And the panelists, y'all can keep going with your presentation, but please respond to the polls because the poll reports will be sent to the CLE Commission as well, so we can log everybody's attendance. If you have any questions, please let me know in the chat. And then there is a panel at the end, so if you have any questions for the speakers, please put them in the question and answer or in the chat, and we will get those to the speakers during the panel. And now I'm going to pass it off to Ian Ford, who's going to introduce everybody and get us started.
Thank you. Hello, everyone. My name is Ian Ford. I'm with the law firm Ford Wallace Thompson in Charleston. And I'll be doing an introduction of everyone, and then I'll be doing part 1. And again, introducing myself, Ian Ford, Ford Wallace Thompson. We have 4 other speakers today. The first is Carmen Ganjasani. Carmen is special counsel with Richardson Plowden in Columbia. So we appreciate her contributing to the Charleston Bar CLE. Carmen's background in appeals is she has researched, drafted, filed briefs in over 100 appeals in the South Carolina Supreme Court, the South Carolina Court of Appeals, the Supreme Court of the United States on behalf of indigent criminal defendants and others. She will be doing nuts and bolts, which is part 2. Part 3, writing the brief, will be done by John Fletcher. He is at Barnwell, Whaley, Patterson, and Helms. The website says he is special counsel, but I think he should be called very special counsel. He's from Pittsburgh originally, and I assume he spent his childhood in the coal mines there. I've been on the other side of John many, many times, and I can tell you he is a formidable opponent, but he is also a gentleman and a nice guy. and he will be writing the brief. Next is Dawes Cook, Barnwell, Whaley, Patterson, and Helms. And Dawes, have you made partner yet over there? I couldn't tell. Anyways, I hope you did.
I have to ask John that.
Right, I know you've been trying
Right.
over there. And Dawes has done about everything there is to do in South Carolina law. He's former president of the South Carolina Bar and many other things. It's really easier to describe what he has not done. He's probably not been on tour with the Arctic Monkeys this year, but it's still 2020. Everything else he's probably done, and he will be doing blessedly arguing the appeal, part 4. Part 5 is Ainsley Tillman. Ms. Tillman is a bit of a mystery, but there are a few things we do know about her. We know she grew up in Afghanistan. She was probably educated there. We don't know for sure. We do know that by the age of 14, she had written the definitive treatise on Immanuel Kant, but she did it in Old High German, so you can get that on Amazon if you want. It's in 4 parts. At some point, she came to the United States, and she's now an attorney with Ford Wallace Thompson, which I hear is an excellent firm. She's also a good writer, a smart lady, and she will be doing the part on the Supreme Court. Okay. I would say any questions about that, but I kind of feel like I'm talking to myself here in my office. I'm going to share my screen and then start on part 1. Let's see, screen share. Dawes, can you all see those slides? All right, great.
Yep, I see it.
Great, I'm gonna start my timer so I don't go past my time, although I may be in it. Okay, so I'm doing part 1, pre-appeal issues. And in a seminar like this, it's nice to start with the basics. And the basics is making sure you are capable of appealing. And with most things in the law, that involves preparation. And we've all been in the trial courts. We've all done motions. We've all done trials. The preparation for an appeal starts there. And I don't mean, whether you'll appeal or not. That I would respectfully suggest is a decision for a different day during your motion or your trial. But for starters, what we want is to make sure you can appeal. And to do that, you have to preserve the issues. And we're all servants of our clients. That is our entire purpose when we go into court, in addition to serving the judicial branch of the state of South Carolina and the United States. So, our first service to the client is to leave their options open to the extent allowed and appropriate. And to do that, we have to preserve the issues for appeal. And none of us want to have an uncomfortable discussion with our client where they are outraged about something and it wasn't preserved for appeal and it's been closed off. So to do that, we start off with the basics. How do we preserve an issue for appeal? And all of you know there's no plain error rule in South Carolina. That's not a secret. You don't need me to tell you that. Who doesn't know that are our clients and often our outside counsel from out of state. So one of the first things we need to do is educate both of them on how it's done in South Carolina, and that is instead the issue preservation rule. And what that means is we have to follow essentially an algorithm to save issues for appeal. And it's not hard, generally it's not hard, but you do have to do each of the steps. And this is set out in the cases and so on. And the first issue is that the first part of the algorithm, it's 4 steps, is it has to be raised and ruled upon by the lower court. That may seem obvious. That may seem self-evident. If you file a motion for summary judgment on statute of limitations and it's granted or it's preserved, you get that for this regard. What's a little less obvious is when you're in the middle of an argument and something else comes up, or you're in the middle of a trial and you go down a rabbit trail, as often happens, and instead of you know, whether a statute of limitations ruling is issued, you're going on whether something was open and obvious, and you're not discussing that terms and so on. You have to raise that specifically on the record and get the court to rule on it. And you need to, if the court just pushes it aside, not that they do, most judges are fair, but there are occasions where a judge will just leave it undiscussed. You'll argue it, you'll move on, the messiness of a court hearing, and you don't get a clear ruling one way or the other. We need to provoke, and I don't mean that unkindly, but we need to get the court to rule on it. Yes, no, you almost don't care for purposes of preserving it. But we do need to get the court to rule on it. And if they don't, we need to ask them to do a motion to reconsider or clarify it. Second point is that has to be raised by the appellant. That's you. It's not enough if my friend John Fletcher raises something and we argue about it, and then the court issues a ruling and I think, well, we've argued about it. I got it. You need to be careful and say the appellant. I too am raising that on behalf of my client, and the ruling, to the extent needed, you know, I want to preserve for appeal. And for me personally, when something like that's happened, I will actually say it on the record, you know, for purposes of preserving this for appeal, you know, we are raising this as well and adopting it and so on. And it's easy to do this point too. It's not rocket surgery, but it is part of the algorithm that you have to do, especially in multi-party cases. You know, my construction lawyers out there and so on, where you've got however many dozen parties and then somebody's arguing it and you think, well, that's been preserved. Make sure you are preserving it on behalf of your client. And that can be easy to do. You just stand up, all those people stand up and say, I adopt this and so on. That's what they're doing in part. Third part, it has to be raised by a timely manner. That means, you know, at the time of it comes up, you can't backdate it much later. The safer thing is to just preserve it there, sort of put a pin in it, again, to leave your client the option, should he, she, it want to preserve it or appeal it later, but raise it at the time and just make sure you're following the algorithm in that regard. Finally, it has to be done with sufficient specificity. And this is hopefully self-evident, but for example, if you're in court and you object on behalf of constitutional grounds, that may be true. And the judge may know what you're talking about, you may know what you're talking about, but make sure you're sufficiently specific on whatever your objection is specifically under the rules of evidence. I wouldn't just say rules of evidence, hearsay, you know, whatever you think the proper rule is. A lot of times you'll object and the judge will know exactly what you're saying, will say overruled, you know, because he or she is thinking the same thing you're thinking. Just get it on the record with sufficient specificity so that you've got it preserved. So this is the basic algorithm of what we're doing when we preserve things for appeal. And if you just have these in your mind and make sure you're ticking them off, you should be fine. It's when you skip a step inadvertently in the messiness of a courtroom that it can suddenly become a problem for your client. And as we know, one of our responsibilities as their advocate and representative is to leave them options and to comply with these rules. Second point, a little more complicated. So we've covered the basics. Let's talk about something a little more complicated, which is interlocutory appeal. And y'all know this means the middle of the case. And typically the conventional wisdom, and it's right, is you appeal a final ruling. But there are situations when in the middle of the case, someone needs to appeal something or has the option to appeal it, which again, if we're serving our clients, is just as important so they understand their legal rights. It can be done. It can be important. And it often comes up in the middle. I've seen it less in trials because you're in the middle of the trial at that moment, except for method of trial, which is an exception to it and its own thing. But what it can come up with is in these complex motions. And we're doing complex cross motions for summary judgment. The court is issuing rulings and denying rulings and so on. And y'all have been involved in those. And then what sometimes happens is our state court judges has one of the parties write the order. And that's what they do. And the judge edits as he or she sees fit and signs it often. And it arises when sometimes, certainly no one on this call, but sometimes lawyers will try to stuff those with findings of facts and conclusions that really help them, that may have been beyond the scope of exactly what was at issue that day. And we've all seen those, like, this is quite an order. At that point, you need to stop. And if the judge signs it, I mean, first thing to do is raise it and say, this is beyond, and you're putting me in a position, Your Honor, where I may need to take an interlocutory appeal. But if they do, the judge does sign it and decides that's appropriate, you need to look very hard at that and see if you need to take an interlocutory appeal as to some of those findings, because we'll discuss in the next section, that could become the law of the case, and it becomes a very, very important issue. So here are the, again, it's not quite an algorithm. There are more factors under South Carolina Code 14.3.330. If it involves the merits, that's a big deal. Y'all can probably imagine a lot of things where it does involve the merits, and this is all set out in the statute. Orders affecting a substantial right, and there's additional wording in the statute on that. And here are some are of the subcategories. In effect, determines the action, affects new trial, which is what I mentioned, or strikes a pleading, which would probably be a dispositive motion anyway. Some lesser known ones are regarding an injunction or a receiver. And when I read Justice Toll's book on appeals, she said, well, these are rarely used. And I thought that's odd because I use them all the time. And what I mean by that is sometimes when you have a receiver appointed, you're in a large scale foreclosure or something situation, that can be a big deal. And the documents often allow, these bank documents, a receiver appointed, and they exercise their right and they do it. You get an interlocutory appeal on that automatically under the statute. And that can be something the other side didn't anticipate, but know that you have the option. Your client may not want to. They're probably in that situation because they don't have money for an interlocutory appeal, but give them the option because that is part of our job. Final point is law of the case doctrine. And at this point, we're going deep as we can go in 15 minutes. This isn't similar to an interlocutory appeal, but different. And we all know what law of the case doctrine is, but probably we don't all know exactly what it is because it sounds self-evident, but you don't tend to learn this in law school. You kind of pick it up along the way, but it does have a definition. And here it is under Black's. That doctrine when a point or question arising in the course of a lawsuit has been finally decided. That legal principle or rule is applicable to the facts governing lawsuit and later as it goes forward. In other words, as we all know, the judge makes a ruling that binds us going forward in that case. And this can become very, very important for purposes of preserving issues for appeal. And I would refer you to a recent case that's been cited 2019 and is currently has been briefed to the South Carolina Supreme Court as being argued there. And it can be very, very important. So no pressure on the lawyers who will be arguing that. They should just relax, but it could be ground setting for them in their career, Ainsley. So here is some of the wording from the Court of Appeals here. An unappealed ruling is a law of the case. It requires affirmance. And it goes on, but look at this very carefully. What happened in this case, I'm not gonna brief it, but I will give you the gist of it in my remaining 3 minutes. And that is, it was an easement case, so I've already got your attention. Then what happened is there were cross motions for summary judgment. Some were affirmed, some were denied, and order was issued. And that order had specific findings, as they often do. Then the case went to trial, and the trial attorneys fought over, well, what had been decided factually in that summary judgment order. And ultimately one side won and one side didn't lose. And what was decided was those where the trial judge, we all know a trial judge one circuit court judge cannot overrule another circuit court judge. You have to go up for that. And what the Court of Appeals basically said was that summary judgment findings of fact bound the trial judge. And that trial judge, to the extent he allowed evidence in and ruled contrary to that, was in error. And therefore, that part was reversed. And that is very, very important, because when you get these summary judgment rulings, these complex things, you need to think very carefully about those findings of fact, especially if the other lawyer has stuffed a bunch of stuff in there, which none of us would do, but I've heard it happen. Because those become the law of the case. And under this ruling, an unappealed ruling is the law of the case. It doesn't necessarily have to be the entire opinion, although that's important. It can be pieces of it. And those bind you and your clients going forward. So that you can read the rest of it here. The law of the case applies both to those issues explicitly decided and those that weren't necessarily decided sort of previously in the case. So the bottom line on this particular doctrine in my 51 seconds is whenever you get a ruling by the judge, you need to look at that carefully and say, can my client accept each piece of this, or are they going to be bound by some extraneous thing, something you disagree with? And if you don't like it, you move to reconsider, as we know. And I have done this, say, I am going to have to appeal this, judge. These 3 lines really are beyond the scope, and I'm going to have to take an interlocutory appeal. Couldn't you just do a Form 4? And I have judges do that, and I've had them nod, and we have to take it up. Or the client says, all right, I'm willing to live with it. But just go there having given your client good advice on it, and keep your eye on Ralph versus McLaughlin, because it will be argued to the South Carolina Supreme Court, I think in December, and it could have a potential impact on this issue. And with that, my time is up, and I'm going to pass this over to Carmen Ganjasani, who is going to tell us about nuts and bolts. I've preserved the issue. Carmen's going to tell us how to carry it forward.
Carmen, you're muted.
Okay, can you hear me now? I thought I unmuted. Am I unmuted? Okay. Let me try to get this up here. Okay, can everybody see this? Okay, I'm going to talk today about the nuts and bolts of an appeal and try to do this in 15 minutes, even though it might be a little bit hard to do, so I'll try to talk quickly. As we all know, appeals in South Carolina are governed by the South Carolina Appellate Court rules. This might not be the most exciting topic to go over the rules, but it's very important because while South Carolina allows appeals, I mean, it's not totally a right. You have to follow the rules. If you don't perfect your appeal, it will be dismissed and you will not get to continue your appeal. So it's very important to always read the rules and know them. And so I'm going to go through a few here. It's not everything, so I always suggest reading the rules. Of course, as Ian kind of already talked about, you can appeal from any final judgment. You must be a party that's aggrieved. You must have some sort of, your personal or property interest must be affected. And also he already went over, I just mentioned again, 14.3.330, which will define what types of orders may be appealed and what interlocutories orders you can appeal. And before I get too into the rules, I want to note a few things about the appellate court rules that are sometimes different from the regular civil rules. Filing is done, you can hand deliver to the appellate court clerk, or you can mail it, and filing will be considered, if you mail it, it will be considered filed that day. You can also serve and it will be complete upon mailing. The biggest thing I see that people make a mistake about in the appellate court with terms of timing is that there is no additional time added when someone serves you by mail. Like in the regular civil rules, I think you get to add 5 days. You do not get to do that. So if somebody sends you a brief on August 1st, they mail it that day. Even though you don't get it in the mail a few days later, your time started running from August 1st. So that's important to remember. With that said, I will just turn everybody to the order issued on May 29th, the coronavirus emergency order by the appellate courts, which does allow filing by email. There's a OneDrive or fax, and you now can serve upon an attorney upon that email address in AIS. And this order is also beneficial. It eliminates the need for additional copies. It waives certain requirements like the binding and having the colored covers. And you can also, it waives fees for when you file a motion for an extension. So it's very helpful. So just kind of keep that in mind in the backdrop of the rest of my presentation. So to start an appeal, of course, it's the notice of appeal, and that's the most important thing. It must be served. In civil cases, you have 30 days after you receive a notice of the order, and in criminal cases, that is 10 days. And this is important. You must serve within that time period. You must serve the respondents. If you do not, that time period cannot be extended, and the appellate court will not have jurisdiction. There is nothing that can be done about that. So that is the key deadline. And another thing that's important to remember, the time commences from when you receive notice of the entry of the order, not the order itself. So if you get an email from a judge that says, I'm filing this order today, and for some reason, maybe you're in one of the courts that's not on e-filing, and so they mail it out the next day, you already have notice that day. I think this is becoming less of an issue because of e-filing. So normally everything you're going to receive on the same day, but there's probably still a few courts that mail the orders out. But like I said, what is key is when you have notice that it was entered, not when you receive the order. And that is somewhere that parties have made mistakes before. You want to file the notice, of course, with the Court of Appeals or the appellate court, and then also with the clerk of the lower court. You actually have 10 days after you serve it to do that. But my practice is I do everything on the same day. I serve, and then I mail to the Court of Appeals, and I also file with the circuit court. Either if they have the e-filing, I'll file it that way. And I'll note all that in my certificate of service, how I served the respondent and how I filed with the lower court. I do it all on the same day. And all your appeals are going to pretty much be filed with the Court of Appeals, except there are a few cases reserved for Supreme Court, which is like death sentence, election procedures, public finance, abortion of minors, state grand jury, and constitutionality of laws. If you mess up, there is a provision where the courts, they will transfer it to the correct court. And a notice of appeal is pretty simple. You just state the orders that you're appealing, state when you receive notice of those orders, attach the orders, attach your proof of service, and submit your $200 and $250 filing fee. There are some criminal cases where you need to give further explanation, but if you have one of those cases, just look at the rule. And also there are also forms at the end of the rule, so you can look at those forms on how to set up your notice of appeal. The next thing you want to do after that is you need to order the transcript. You have 10 days in criminal cases after you serve the notice, in civil cases after you serve the notice, 30 in criminal cases. And you must order the entire transcript unless the parties agree otherwise. If you need to find your court reporter, there is a section on the South Carolina Judicial website that has a link on the front page that says, it tells you how you can find your court reporter if you don't know who your court reporter is. Now they require you to email it to court administration at that transcript email, and email to the court reporter, and of course send to the court and the parties. The court reporter does have 60 days to deliver the transcript, so don't harass the court reporters. They can get extensions. If for some reason you have not received it within 10 days of when you think you were supposed to receive it, let the appellate court know. You'll also copy court administration and the court reporter. When you do receive the transcript, also let the appellate court know. And finally, I always just remind attorneys that it's your responsibility to pay the court reporter, even if you think your client should be paying. There have been attorneys that have been disciplined by the Supreme Court when they have not paid their court reporters. So you need to do that and work that out with your client later. So after you do receive the transcript, your initial brief of appellant will be due 30 days after that. And again, respondents is 30 days after the appellants, and the reply, if there is going to be one, would be due 10 days after the respondent's brief. I have found that the Court of Appeals typically permits up to 2 extensions of 30 days. They don't like to go beyond that anymore. Your first extension request, you can actually just submit a letter and just explain your reasons why you need an extension. And then after that, you want to file a motion, and I usually get consent of the other side on my second request. Typically a $50 filing fee, but note right now that fee is waived. And I won't go into the briefs, but the rule sets forth the required contents for a brief or table of contents, statement of issues on appeal, statement of the case, standard of review, argument, conclusion. Just make sure you're following those requirements. When you file your initial briefs, you will also include your designation of matter that you want included in the record on appeal. This is simply just a list of the material that you want put in that record, and it's typically things you are citing to in your brief. But I've always said, don't let it just be an afterthought. You should note that the appellate court, they really cannot consider any fact that's not in the record. If you don't put it in there, it's as if it does not exist to the court. And so if you are an appellant, you want to make sure you have a sufficient record, all the trial court rulings that are applicable to your issues, the evidence applicable to your issues. You have to have a record that the appellate court has enough material that they can review the errors. There's been opinions where the Court of Appeals has just said, we did not have enough in this record to review the errors, and they will not review that error. On the other side, you don't want to designate material that was not presented to the trial court, and you don't want to designate a bunch of material that was irrelevant to the appeal, has nothing to do with your issues. In fact, you must certify in your designations that you have not designated any material that is irrelevant. And so that's, I kind of call it, you don't want to throw in the whole kitchen sink. You don't want to have the entire trial transcript and all 60 exhibits when maybe you have a limited issue. And I say this for respondents too. If the appellant has really only raised one issue, there's no reason to harass and make the appellant put in, like I said, all 60 exhibits in the whole transcript. There are provisions in the rules that can allow the appellant putting that together to basically seek cost if the respondent has put in too much material. And again, you don't want the appellate court to have to muddle through a bunch of irrelevant material when they're trying to read what is important to your issues. And again, the record on appeal, you will then serve 30 days after that last brief. And you can serve one copy on the respondent, and you can file the proof of service at that time, but you actually don't have to do the court copies until your final briefs are due. And this is what I usually do, is I make that one copy for the other side. I send it to them. I say, can you look at this, make sure I did not forget anything, or maybe there's something that we cited in our briefs and we just forgot to designate, and we need it in the record. A lot of that can be worked out without court intervention. You can get the record all corrected with the other side, and that way you have not already made 15 copies of an incorrect record for the court. You know, you can get with the other side, make sure it's correct, and then make all your copies so you're not wasting money. And again, you must include all the designated material. And I will note, if somebody in their designations is designating material that wasn't included before the lower court, I would move to, and they won't agree to move that, strike that or take it out. You can move then, before you even prepare your record, move the court to strike, to require the party to strike that material. Because the record is the foundation for the court's review, you want it well organized, user-friendly, have clear exhibits, color copies of exhibits where required. You want the court, you know, this is what they are reviewing, and they want to see something professional. You don't want them to be, like I said, muddling through and having kind of a subconscious believe that because you did not put together a good record that maybe you don't have a good argument. This is kind of the general form. You'll have a title page, your index. This is sort of the orders, pleadings, transcripts, exhibits, other documents. And under each of those headings, you'll specifically list each order, pleading, all the exhibits, and you want it clear. So each exhibit you should describe, and it should have a corresponding page number in the record so that courts can easily find that. The certificate of counsel is another certification that you have not included anything in the record that was not in the designations. I also use this to certify that I complied with an order. There's an order April 14, 2015, the privacy order. So you need to redact your record according to that, obviously taking out date of birth, social security numbers, financial numbers, and I usually certify I have complied with that as well. Witness testimony, under the transcripts, the court likes you to break it down for them and break down the direct cross. Again, this is just an easy way for the court, if they want to go directly to part of an examination of a witness, they will have that. And that's also required by the rules. After you do your record on appeal, that's when you do your final briefs. You have 20 days. Of course, in typical times, you have your blue, red, gray covers. Right now, that is waived under the coronavirus order since most people are just emailing these briefs. Your final briefs are going to be exactly like your initial briefs, except you're going to have those record cites, which I show here. That's typically how a record is cited. And the only things you can change are just obvious typographical errors and misspellings. Do not change anything else. I have seen attorneys add whole new arguments to final briefs, and I usually move to strike those new arguments if they do that. Once the final briefs are filed, you're going to be sitting for a while waiting for the court to decide, are they going to schedule oral argument or decide the appeal on the briefs. Right now, I will say that's running a long time. I have an oral argument that's probably going to be held in December, and it will have been 1 year and 10 months since I filed my final briefs. I don't know if some of that's coronavirus related, but I usually tell people just check on your appeal about once a month while you're sitting, just to make sure you haven't missed a letter that it was put on a roster, because these appeals are sitting so long. But the court will let you know when they think they might schedule. They'll send you a conflicts letter with a date to respond by. So if you have a conflict, respond. And then of course, they'll let you know when the oral argument's scheduled. And opinions as well. They can be issued anywhere from 3 weeks to, I've seen some up to a year after oral argument. So you don't necessarily know when those opinions are going to come out. And another thing, opinions can be affirmed upon any ground appearing in the record, which is helpful for respondents. So even if you didn't raise an argument at the trial court, if it's in the record, you can raise a respondent can raise those additional sustaining grounds in their brief, and the court can affirm on that in their opinions. Get your opinion, you don't like it, you have 15 days to file your petition for rehearing. It must actually be received, so don't wait and mail on the last day. They have to have it in hand. And you must file a petition if you intend to go to the Supreme Court. And I usually, I talk to my clients, and if we do decide not to move ahead to the Supreme Court and not to file a petition for rehearing, I always make sure I have that in writing from my client, just even for an email, so that they know we aren't moving ahead, so that if I don't file that petition for rehearing, we all are on the same page. And again, right now, you cannot file a return unless the court requests it, and they'll let you know that. Moving on, after you get your order denying the petition for rehearing, you have 30 days to file your cert petition with the Supreme Court, which again includes that $250 filing fee. I believe Ansley's going to talk more about this, but I will also note there was an order back in July 16, 2014, which limits extensions. You have like 20 days total that you can use across the whole Supreme Court process. I know with the coronavirus order, they're being a little more generous with extensions, but just always remember that order and read it if you're going to go ahead with petition for writ of certiorari. After the case is over, if you have prevailed, let your client know you can move for cost. Rule 222 applies in everything except if the Supreme Court has granted cert. You'll see another rule applies, but typically you could seek your filing fees, your transcript cost, the cost of printing, your briefs and record, and you can get an attorney's fee, which is set right now at $2,500. And like I said, if the Supreme Court did grant cert and you prevailed there, you'll get any additional filing fees there and printing costs, and you can get another $2,500. So some people, I've seen some attorneys just that win that seem to forget about that, but always just let your client know that you can move for cost. Finally, if for some reason you have missed one of the rules or one of the deadlines, and I will say the court's pretty good. If you miss a deadline, they often send a letter first letting you know about it and giving you 10 extra days. But if for some reason you still are missing the deadlines and the court has dismissed your appeal, you can move to reinstate. You have 15 days to move to reinstate the appeal. This is like a petition for hearing. It must actually be received by the court. I haven't really seen attorneys get caught up in this. Where I see this a lot is with pro se parties, and the court seems to be fairly generous on granting their motions to reinstate because they usually have some reason why they missed a deadline. And finally, these are just kind of my go-to resources. Like I said, all the sample forms are in the appendix to the rules, so use those. If there's any other kind of form, I'm always willing to send people my forms. And then, of course, what I call a Bible of appellate practice in South Carolina. If you are going to be doing an appeal, this book, The Appellate Practice in South Carolina, it covers the standard of review. It covers all the interlocutory orders. It covers almost everything you need. So I really suggest reading that book. And with that, I will probably pass my portion on to John Fletcher.
Good afternoon, everyone. Can everybody hear me okay? Ian, we're good? I want to thank Ian for asking me to speak today. And he gave me the subject that is dearest to my heart, which is writing. I've always considered effective legal writing to be the most important part of a legal practice. It sets the tone for any oral arguments, and it really forces you to analyze your case in a very analytical way.
John,
and
I hate to interrupt you. I'm going to launch the first poll real quick. You can keep going. I just wanted to let everybody know I'm launching it.
Okay, thank you. So today I'm going to talk to you about you're going to get ripped off. You're only getting 3 commandments today, but my 3 commandments of effective appellate brief writing. And the first commandment is, thou shalt remember you are not in the trial court. There are major differences between what you're trying to accomplish in the trial court and appellate court, your audiences, and what you can work with. The most important rule under this is, do not recycle your trial court brief. I think the judges can tell when you do that. It's not going to be as deep in its analysis, and it's not going to focus on what you're trying to accomplish in the appeal. Remember, your appeal purpose is different from the trial court. The trial court, you're looking to build a case factually and convince the judge that ruling in your client's favor is the most appropriate resolution to this dispute. When you're on appeal, you've got a closed record, and you're trying to convince a judge that, or a panel of judges, that what the trial court did was either incorrect or correct. And that's a different task. So you have to make sure that you follow certain rules to make sure that your appellate brief is as effective as possible. First is, I always include in my appellate briefs a discussion of the preservation of the issue below. As Ian mentioned at the beginning, that's an important thing that people often overlook in their trial court proceedings. So when you get up to the appellate court, you need to remind the court that you're timely, that you properly preserve the issue on appeal, and that the trial court properly ruled upon it. Additionally, when you're, and this is more of a point when you're at the trial court, on appeal, you wind up with a closed record. And so when you're at your trial court, you not only need to preserve things legally, but you need to support them factually and with evidence. I've seen many cases where a lawyer argues something to a judge, but doesn't produce the evidence to back it up, and you get on the appellate level, unless it's been actually presented to and considered by the trial judge, made part of the record, you can't cite it on appeal. So you need to be very, very cognizant, even before you get to the appellate court, that you're going to have the evidence to back up your arguments. So another part of the appellate brief that's not part of your trial court brief is doing your designation of matter for inclusion in the record. Anything that you cite in your appellate brief, you need to make sure that at the same time you serve that initial brief, you serve a designation that identifies that document. My practice generally is I have 2 documents open at the same time, and every time I cite a fact or something from the record in my brief, I note it in my designation. And at the end, I go through and make sure that everything I cite in my brief is included in my designation. If you fail to do that, you can cause substantial delay in the appeal. If you need to request leave of the court to update or to amend your designation, that can insert a unnecessary delay in the appeal. Another thing that makes the appellate brief different from the trial court brief is that when you're on appeal, you need to have a stronger focus on public policy. Not convincing the judge just why this rule or this ruling is appropriate in this case, but why it's a good rule for everyone. And why this, because a trial judge is less concerned about setting bad precedent than obviously an appellate court. And you need to make sure that you assuage any concerns they have, that if they rule in your favor, they may be creating bad precedent. So I would include that in almost any brief if you can. It doesn't be formal policy, but just the reasons why this is just a good rule, and irrespective of your legal arguments. The other differences include substantial technical differences. You've already heard some of the special technical rules that are applicable in the appellate court that aren't in the trial court. Those could include things like typeface, special things that need to be included in a brief, the sections. Make sure that before you start that brief, you're familiar with all the appellate court rules and all the requirements for the brief in the appellate court. In a more substantive way that the appellate brief is different from the trial court brief is that you need to learn from your mistake or your victory. When you're on appeal, you're asking a court to consider what another judge has done. So first you have to make sure that you emphasize the standard of review, especially if it's in your favor. If you are a respondent and the standard of review is abuse of discretion, and you don't use the word discretion at least 20 times in your brief, you're not being an effective writer. You need to make sure the court knows, all you need to find is this wasn't an abuse of discretion. Conversely, if you're an appellant and it's a de novo review, you know that you can take a more aggressive, and you need to remind the court that it's reviewing the issue de novo. And additionally, you need to learn from what the trial judge told you. You know, in most cases, you're going to have an opinion from the trial court where the judge tells you either what it liked or didn't like about your arguments. Use those. You know, if you're the respondent, quote from the trial court's opinion. You know, let the appellate court know why the trial judge thought your argument was the better argument. If you're the appellant, use that opinion to learn from and see what it was that the trial judge didn't like about your arguments and try to fix that for appeal. Because it's very likely that the same things that bothered the trial judge will bother the appellate court as well. And this is another hint. This is kind of just a tip that I use. The South Carolina appellate courts have an excellent thing on their website. It's the C-Track service. It allows you to find any brief opinion and basically any appeal going back quite some time. During your legal research, during your even your writing process, you can find examples of briefs that have been written by other attorneys. As you're doing research and find an opinion that you find is important to your case, you can go back and find the briefs that were written in that case. That's good to use as go-bys, as additional research, and just ways to learn how other attorneys write to improve your own writing. And the last hint under this is that you need to find your voice. You know, we all have a certain way that we communicate verbally, and I think we all also have a certain way that we communicate in writing. Be true to your own voice. People can tell and judges can tell when you're writing something that isn't who you are. For example, Ian is a very dramatic writer, and he very effectively uses things like literary quotes, humor. That's not my style. And if I try to do that, I'll probably go out, flame out on and have a judge think that I'm being insulting. So you need to be very careful about making sure that you stay true to who you are in the way that you communicate. I know that on appeal, we tend as attorneys to think that we need to be more formal. If your style is not formal writing, don't artificially make yourself formalized. It's not going to make your arguments more effective. I think it's going to, you know, it shows. I mean, if you use words that you don't typically use in your writing in your practice in appeal, it just isn't going to read right. You need to just be true to who you are and what your voice is. And that's, you know, I think that's the best way to make an effective appellate court brief. So the second commandment is thou shalt organize. The least effective appellate briefs I've seen have been briefs that I kind of read them and I'm like, what the heck did I, you know, where are they going with this? What's going, and you get confused trying to figure out what the argument is, where they're building it. When I first started practice, one of the attorneys I work with told me that your briefs should march in a straight line. They should always be focusing on where they're going. If your brief starts going on a side trip or a tangent, it's distracting from the purpose of the brief. So the best way to ensure that your brief marches in a straight line is to outline what you're going to do. It's like, you don't build a house without a blueprint. You shouldn't write a brief without an outline. It doesn't be formal, but you need to know exactly where you're going. I analogize writing an appellate brief to building a house. And when you build a house, a brick house, every brick has a purpose. And every brick goes where it should go. If you start putting bricks where they don't belong or you omit bricks, that's when you have problems. In the same way, in an appellate brief, I view the sentences as bricks. So every sentence should serve a purpose. Every sentence should be directing you toward what you're trying to get the court to do. If you're writing sentences that don't do that, you're not being an effective writer. You're including things that are going to distract the court, and you're going to be less persuasive in your writing. So you need to effectively identify what the issues are, and through your outline, determine what headings and subdivisions you're going to use in your brief. Especially at the appellate court level, the effective use of headings is extremely important. You're going to have a table of contents at the beginning of your brief, and that's going to lay out basically for the court where you're going, and lay out all the issues and all the arguments. Every separate issue I discuss or argue should have a separate heading. In that regard, you also need to ensure that you write effective identifications of the statement of the issues. Especially if you're the appellant, that's going to be your preservation in the appellate court. You need to identify for the court exactly what issues you're arguing for them, and if you forget something in those issues, you're going to be out of luck. So you need to be very careful that you, A, preserve everything in your issues, and B, make arguments that correlate to those issues. So what I like to do is, if I've got 5 issues in my identification statement of issues, I have 5 subheadings addressing each of those issues. And that way the court can correlate exactly what I'm arguing and not have to go back and forth. Conversely, if as a respondent, I tend to kind of follow the leader. And if they've got a certain heading or arrangement, I tend to follow that arrangement if I can. Again, it allows the Court of Appeals to kind of see, okay, well, in section A2, they're doing this, and here's how they respond to it. And they don't have to go searching through your brief to find where you're responding to a particular argument. So that's the second commandment. And the third commandment is thou shalt edit and edit and edit and edit and edit and edit and edit. A lot of attorneys, I think they dictate a brief and they get a printout and they go through and look for typos and maybe change a sentence or two and feel like they've edited the brief. When you've got the first version down on your computer, that's just the start of the journey. And with most attorneys now doing a lot of their own typing and their own writing of briefs, it's really easy. You can do 5 minutes here, 10 minutes there, but you just keep editing. Your first product should look nothing like your final product. I've found that every time I review something, I find something else that can make my brief better, can make it more concise, can make it more interesting. And in the editing process, I would recommend that you use the eyes of someone else at the very end to go through for typographical and other errors. I know that when you edit a lot like I do, you tend to get tunnel vision, and you sometimes don't see the mistakes that are right in front of your face. And you're reading what your mind is telling you that you're thinking, but that's what's not necessarily on the paper. So it's always helpful to have someone at the very end to go through and check out for those things. So in the editing process, my primary goal typically is to trim the fat. Look at every sentence and ask yourself, is there a way that I can say this that's more concise, more persuasive, more interesting? And I guarantee you that you'll find that the majority of what you've written in your first draft can be said better. And the next thing that I typically do in my editing is I try to make my writing active. The passive voice is not how we speak. It's not how we generally communicate. And the passive voice in legal writing is the first thing that's going to, I think, put people to sleep. The car was not driven by somebody. Somebody drove the car. And it makes your writing active. It makes it doing something. It grabs attention. And an effective way to kind of cut that out of your writing is at the very end, before you get ready to finalize the brief, do word searches for the telltale signs of passive voice. Words like by, was, were. Anytime you use those words, check and make sure that you can't be saying that in a more active and efficient way. Additionally, in the editing process, you need to go back and look for your crutches. Are there repetitive words that you constantly use that you can be interjecting some synonyms or other things that can avoid you getting in a path of just repetitive statement of the same thing over and over and over again the same way. Look for technical jargon that you might be using that you understand, but needs to be maybe made a little more simplified for an appellate court to understand it. And that's really about all I have. So I want to thank everyone for your attention. And I'm going to pass it over for oral argument. And again, I think the writing really kind of leads into your oral argument. You can't effectively be an oral advocate if you can't be an effective written advocate. And Dawes is the best written and oral advocate I know. So Dawes Cook, take over.
Thank you, John. You still have your job. That's I appreciate the introduction. I'd like to say that for me, oral argument is just reading to the court the briefs that John has written, but there's a bit more to it than that. Part of what I'm going to talk about is well known and written about. In fact, I'm going to quote from some authors on oral advocacy, but a lot of it is just practical things that I've discovered over the years, and some of it's personal to me and or may not work for you. The first thing I think to remember about arguing an appeal is that it's been a long time since you filed your brief. I just got notice this morning of an oral argument that's going to happen in November on a case in the Court of Appeals that was fully briefed in July 2018. So that's more than 2 years. I don't even remember what the issues were in the case, let alone the facts, but you have to know the record inside and out. So you just need to, when your case is set for oral argument, you've got to take the time, and some people will just go check into a hotel for a day or 2 days and just read the record inside and out. My personal style is I like to use sticky tabs. I just use a regular sticky tab, and I'll put a number on it and mark it in the page, and then I'll highlight within the page the part that I want to be able to refer to. Some of you may be different, but when I get up there in front of the podium to start oral argument, everything goes blank for me. It's almost like I'm hyperventilating and I get tunnel vision, and so I can't read a lot of busy things. So I have to keep it very simple, and I like to have a very simple outline, cross-referenced with annotations to the record or to the cases or the authorities that I'm going to be referring to. I don't have a good memory for names, numbers, cases, and things, so I've got to write it down. If I'm going to quote something, I've got to have it written out pretty much for me to quote. By the same token, you have to update your legal research. Again, it's this appeal I'm going to argue in November. It's been 2 years, more than 2 years since we briefed it. There could be new cases out. I don't necessarily catch them all when they come. And so I'll sit down, I'll spend some time going through, and I'll ask John to help me probably to determine whether there's been any new case law, whether it's, even if it's just repeating, well-known principles. It's good to have that and to be current when you're on your feet, because the court certainly will be current with it. My outline, I don't write out my argument. Oftentimes I will literally write out my first paragraph, because I think it's very important to, when you get up there and you're kind of hyperventilating and getting your tunnel vision, that you get your first sentence or paragraph out of your mouth. And then I tend to relax, and I'm able to kind of move around a little bit and look at my notes. So I like to have my first sentence or paragraph already written out and memorized. I don't like for my notes to be too busy for that same reason that I just said. I can remember one of the first times I got up to do an oral argument, I had the whole thing typed out. I looked down, all I could see was a blank page. I could not read the type on it. It was too small. It was too close together. I was trying to make eye contact with the judges. So that's not good for me. It's maybe good for some people, but what I like is to write my notes in my own handwriting so that I can write things in different size. I can highlight, I can put stars by things that are important to me. Typically what I'll do is, again, I'll do it in outline form. The only time I'll actually write a sentence out after my opening statement is if there's something that I want to quote, if it's a statute or an excerpt from a court. I don't mind having a photocopy of the case or the statute and then highlight that, but I always tab it so that when I look down at my note and I'm at that part of the argument, usually I'll actually highlight it in my outline, and I'll put a star next to it, which is my little signal that I'm getting ready to go to one of my references, either a quote from the record or a quote from a case or a statute or some authority. And I'll look right down there. It'll be a star and it'll say number 1. And I'll have a little summary of what it is, but I'll go right to my text and I'll pull up number 1 and open it up. And if all has gone well, it's all going to be highlighted right there for me to read. The court does not care for seeing you leaf through things when they ask you questions about the record. You know, you're looking at several hundred pages of record. You don't have your wits about you or the time, and the court doesn't want to sit there while you pour through the record. So it's very important that you know it very well and that you have it tabbed so that you can find what you're looking for. In terms of preparation, Many people like to do moot courts. I've done some, I'll be honest. I don't do a moot court in most of my arguments. I do have a tip for you that if you ever have a case that goes to the US Supreme Court, the minute that you find out that cert's been granted, you need to make a call to the Georgetown University Supreme Court Institute and ask them to do a moot court for you, because they do that. They have professors who actually impersonate the justices on the Supreme Court, and they'll do a real moot court, but they only do it for one side. They do it for the side that calls first. And so you should do that even before you call your whoever you're going to hire to do your briefing and your argument for you in the Supreme Court. But a moot court can be helpful, but I do my own moot courts for myself typically. And what that is for me is trying to imagine every possible question that the court's going to ask you, because we drink our own Kool-Aid. We write our briefs. We really think we've made our argument well, but what you need to be ready for in oral argument is to address your weak spots, or the parts that you haven't addressed, or the parts that the other side has addressed. And so I spend most of my time in preparation after relearning the record and reading the cases and learning the authorities, trying to sort of war game with myself. What questions would I ask if I were the judge trying to pick you apart? A lot of times judges will ask hypothetical questions, and what they're doing with that is trying to test the boundaries of your argument and try to see if they can take you to an absurd position by changing the hypothetical. So you have to be ready for all of those kind of things. I think it's good to watch other arguments. I think you can do it now that everything seems to be online. You can probably watch arguments virtually, but it's good to see the court that you're going to be arguing in front of, whether it's the South Carolina Supreme Court or the South Carolina Court of Appeals or the Fourth Circuit Court of Appeals or the United States Supreme Court. I think it's good to see what the give and take is like, how other advocates handle things. I like to research the judges on a particular issue, whatever the issue is, sort of broadly speaking. It's hard to do it in the South Carolina Court of Appeals and the Fourth Circuit, because you don't know ahead of time who your judges are going to be. I know the Fourth Circuit in particular makes a particular point of keeping it a secret until the morning of your argument who you're going to have. So if you're in the Fourth Circuit, you've got 17 judges to worry about. In the South Carolina Court of Appeals, you've got 10 judges to worry about. But I'll take the time. You just go online and go to Westlaw or Fastcase. I advocate using that to just check and see what any of those judges have said about the subject matter that you're talking about. And sometimes it actually works out. You look up and you say, oh, Judge Smith, as you said in your opinion and such, I think that principle applies here. And that happens more often than you would think. So the day of the argument, get there on time. I live in Charleston. The court's either in Richmond or it's in Columbia. I always worry about what happens if I get a flat tire. So I won't say that I always go up the night before. In Richmond, I certainly do. I always go the night before, the afternoon before, and spend time in the hotel relaxing and studying. And then I'm close enough that you can walk to the court. In Columbia, there have been times when I'll say I've driven the morning, but I get there very early, make sure that if there's any problem, if my car breaks down, I'll still be able to get there. What are your objectives of oral argument? And I'm going to crib this from a book by Justice Scalia and Garner. It's called Making Your Case, The Art of Persuading Judges. It's not a very difficult read. I think they are using it now in the Charleston School of Law, but I read it not too long ago, and it's excellent. It handles all areas of briefing and arguing, both in trial courts and appellate courts. And they give six goals of oral argument in descending order of importance. Number one is to answer any questions and satisfy any doubts that have arisen in the judge's minds. The second is, if you're the counsel for the appellee, to answer new and telling points raised in the appellant's reply brief. Oral argument is your only chance to do that. Number 3 is to call the judge's minds, call to the judge's minds and reinforce the substantive points in your brief. Number 4, to demonstrate to the court by the substance and manner of your presentation that you are trustworthy, open, and forthright. By that, I think they mean your client as well. Number 5, to demonstrate to the court by the substance and manner of your presentation that you have thought long and hard about the case and are familiar with all of its details. And number 6, to demonstrate to the court, mostly by the manner of your presentation, that you are likable and not mean-spirited. That's harder for some people than for others, but again, that's not the number 1 priority for oral argument, but it's one of the 6 that they identify. As I said earlier, I always like to memorize the beginning and I also like to memorize the end of my argument. John made a great point, and that is one of the big differences between appellate argument and argument before a trial judge is that with the trial judge, oftentimes you're just citing what the precedent is or what the statute says and applying established law. In the Court of Appeals, you are talking about policy. It's often been said that they decide not what the law is, but what the law should be on a particular topic. In all of my advocacy, I always believe in appealing both to the left brain and the right brain, logic and emotion and passion. You always want to leave, whether it's a jury or an appellate court, you always want to leave them feeling that ruling for you is the right thing to do, not just necessarily what the contract provides or what the statute provides. So you need to, I always like to end my oral argument, and I have to admit I've forgotten to do it sometimes, with some summary of why my position is the best thing. You know, Your Honors, if you take the appellant's position on this, nonprofit corporations will be paralyzed for all eternity, or whatever the bad things would happen through a negative precedent. And if you can't do that, you're probably not going to win the case. But there is a moral righteousness behind almost every position, and you ought to know what it is by the time you get to the Court of Appeals. I've heard it emphasized. It's both in the Scalia book, and I heard a lecture last week by Justice Breyer on oral advocacy. You have got to address your weaknesses. You know, you cannot sweep them under the rug. That's what the court is going to want to hear. They're going to want to hear, how do you address your weak spots? I've had cases where I've just had to look up and say, Your Honor, I admit that's not our best argument, and may I move on? Sometimes you will find yourself mired in an argument with a judge. They're going to keep picking and picking and picking. You're seeing your time run down. I have, on at least a couple of occasions, said, Your Honor, I think we have a difference of opinion on that point. May I move on to my other arguments? You always want to be able to tell them that whatever your weakness is, that it doesn't make any difference to the outcome of the case. And you want to be able to explain to the court why that issue is not dispositive, why your other points are sufficient for them to rule in your favor. The last time I did that, I was in the Fourth Circuit Court of Appeals, and there was a judge who was just obviously not going to agree with a particular position I took. I had other points I wanted to make, and finally I just said to her, I said, Your Honor, you know, we disagree. May I get onto my other points? And she laughed. She said, I'm sorry, I've taken up all your time. You can have some additional time. And so it worked out fine. They still ruled against us, but at least I was able to go on to my other points. Don't be glib. Sometimes judges will joke, but I don't ever start out with a joke or humor. I've seen lawyers try to do that, and all they get was cold stares. I saw in one case a lawyer even being called down for not taking things seriously. So you don't have time to read your audience up there and see if they're going to have a sense of humor. Always answer the questions directly. This is not a presidential debate where the question that the moderator asks is your invitation to pivot to the topic that you really want to talk about. They are acutely aware of whether you have answered their question or not. Don't say, I'm going to get to that later. You've got to be able to answer the question when you get it. My blood turned cold once when one of my co-counsel was arguing in the Fourth Circuit, and the chief judge looked down at him after a while and said, "Sir, do you have a constitutional aversion to answering my questions? You don't want to be in that position." But that makes your outline all that important, because when they ask you that question, they're going to get you off of your scheduled argument. You've got to have your outline clean enough and readable enough so that you can get back to where you wanted to go after that question was over. Final thing to remember, as John said, this is not a jury argument. It's not even a trial court argument. I was in a court of appeals once and watching an argument before mine, and the lawyer got up. He was a young guy, and he looked up. He said, "Your Honors, this case is all about money." And one of the judges just stopped him cold and said, "Sir, every civil case is about money. Just move on with your argument." So it's good to be dramatic, but it's not a jury argument. So I see my time is up, and I'm going to gladly pass the gavel on to Ainsley. Thank you.
Thanks, Dawes. I'm going to attempt to share my screen now. It worked earlier, so I'm sure it'll work now. I'm talking about the Supreme Court because up until now, you've been in the Court of Appeals where you got there by right. You filed your notice of appeals like Carmen told you to, and they let you right in. The Supreme Court is different. You can't argue there of right. It is a limited access forum. And so how do you get there? And the answer is, it's Wednesday morning, you're reading the advance sheets, you see this Court of Appeals opinion that you've been waiting forever to come out, and there it is. Even though you followed every one of John's brief writing rules, and even though you followed every one of Dawes' argument rules, you still lost, and you lost on every issue, and you lost big. And you're going to appeal it, you say, to the highest court in the land. Not so fast. Not so fast. Before you can petition for certiorari to the Supreme Court, you have got to, there's a procedural prerequisite, and that is that you have got to file a petition for rehearing in the Court of Appeals. And your petition for rehearing is, it's got a limited time frame. You've got 15 days from the day that you receive that Court of Appeals opinion, 15 days to get your petition for rehearing to the Court of Appeals. And when you're in it, and this is not something that you can just dash off. You've got to identify some mistake of fact, misapprehension of law, or something that the Court of Appeals has overlooked within the record that makes their opinion wrong. You cannot just rehash every argument that you already made in your brief to the Court of Appeals. They've already read that. Once they've rendered their opinion, if you're going to move them to change their minds, you've got to point to some specific thing that they have overlooked or misapprehended. And that's the standard for a petition for rehearing. It's right there within the rules. And before you do that, and before you attempt to sway the Court of Appeals as to the decision that it's before you attempt to go to the Supreme Court, you've got to sway the Court of Appeals. The Court of Appeals will ponder your petition for rehearing for a while, but let's just assume that they deny it. Now you can move on. However, as you're moving on to the to the Supreme Court, hopefully, you have raised in your petition for rehearing every issue that you hope to have the Supreme Court hear. Because there is, and Ian touched on this earlier, there is a risk of abandoning issues. And it's in the rules. It's Rule 242 of the Appellate Court Rules, which is the rule about petitions for cert to the Supreme Court. And it says very clearly that only the questions that were raised in the Court of Appeals and in the petition for rehearing shall be included in a petition for writ of certiorari. So that is something to be mindful of as you are drafting your petition for rehearing, because you do not want to abandon an issue, and especially if it's one that is important for the Supreme Court to review. So how do you petition the Supreme Court? And the answer is there's a time frame. It's 30 days. You're going to draft it's not a brief, it's a motion technically, but you are going to draft a carefully crafted work of art per John Flesher. And there is a standard for what the Supreme Court will consider when deciding whether or not to grant certiorari. And this is what you should keep in mind when you are, when you are drafting your petition for certiorari. What the Supreme Court is looking for in deciding whether or not to hear you on your case is, and the factors are within the rules, it is whether there are novel questions of law, whether there is a dissent in the Court of Appeals, whether the decision of the Court of Appeals is in conflict with a prior decision of the Supreme Court, where there's a substantial constitutional issue, or where there's a federal question that's included in the decision of the Court of Appeals conflicts with the decision of the United States Supreme Court. Those are the factors that the Supreme Court is looking for, is hoping that you'll address in your petition for certiorari, which they are going to read and contemplate in deciding whether or not to hear your case. You do have some hope, and that is that the Supreme Court's heart can be moved in other ways. You'll see in purple that it says that those factors are neither controlling nor fully measuring the Supreme Court's discretion or power. So the Supreme Court could be moved in other ways, but a petition for certiorari is an appeal to the Supreme Court to exercise its discretion to review the Court of Appeals decision. And so that is where you want to focus your persuasion as you were drafting that petition. And Carmen touched a lot in her presentation earlier about the procedure for this. It's also within the rules, but if you are petitioning for certiorari, you will have an opportunity to submit your petition, and then the respondent will have an opportunity to submit their response, and then you will have an opportunity to submit a reply. And then the Supreme Court will take it all into its heart and ponder it, usually for months and months, at which point they will either grant you certiorari, and you can go forward to the Supreme Court, or they will deny it. If the Supreme Court denies your petition for writ of certiorari, that is the end of the road for you in your appellate crusade. There is no petition for rehearing of a denial of a petition for certiorari. So, however, if they grant it, you do get to go forward to the Supreme Court. And once you are there, it is a lot of the same. It's a lot of the same from the Court of Appeals. You're going to write a brief again. And your brief is going to be much more substantial than your petition for certiorari was. Your petition for certiorari would have sort of touched on the basic issues that you wanted the Supreme Court to hear. Your brief will flesh out fully the issues of law that the Supreme Court is to consider. And one thing that's interesting about intuitive about the Supreme Court is it's of course the highest court in South Carolina. And not only, whereas the Court of Appeals is bound by precedent, the Supreme Court makes precedent. And the Supreme Court is also bound by previous decisions, but they can overrule those previous decisions. They have that power and that authority, and they can exercise it. So don't be afraid as you're writing your brief. If you think that there is some reason to have precedent overruled, or that the Supreme Court should put aside a previous case, go ahead and argue it in your brief. You can do that. However, and there is a rule for this, and this is Rule 217. Rule 217 says that you can argue against precedent to your heart's content within your brief. However, if you go before the Supreme Court in oral argument and you just stand up there and argue against precedent, it will call you on it. And I've seen this happen. It is mortifying. If you are planning to argue against precedent, you need to have moved, at least as it says in the rule, at least 15 days prior to the date of your oral argument to argue against precedent. And having done that, if the Supreme Court grants your motion, then you can argue against precedent. But whatever you do not go before the Supreme Court planning to argue that a previous decision was wrong for whatever reason without having first asked the court to do so. And so, again, you will have submitted your brief, which may contain an argument against precedent. It certainly should contain everything that John told you earlier to do. And then after you submit your brief, you will have a long period of time. As Carmen mentioned earlier, it can be more than a year before the Supreme Court decides whether or not it's going to hear an oral argument and when that oral argument will be. And you will go before the Supreme Court at your oral argument date. And having argued in the Court of Appeals earlier in the case, you may think that you know what you're getting into. The Supreme Court argument is an entirely different thing. It's a 5-judge panel with peppering questions at you, and you should prepare all day long, all week long, in advance, just like Dawes told you. You should know your record cold. You should have anticipated psychically every question that they might ask you. The best way to do that is to read the respondent's brief and hunt down the cases that the respondent has cited and know what they say, know how they might be applied, know how they can be distinguished. So that will be your argument. After your argument, you're going to wait, and you will wait for a long time before the Supreme Court issues its decision. And then one Wednesday morning, you'll be reading the advance sheets, and there will be the Supreme Court may rule against you. Who would have thought, on every issue? And if they do that, is that the end of the line for you? And the answer is no. If the Supreme Court has ruled against you, you still have a shot to move the heart of the Supreme Court justices to rehear your case, to rehear your appeal. And to do that, you would go back to the petition for rehearing, much like the one that you had drafted earlier, in order to move the heart of the Court of Appeals. And the standard for that, again, is that you've got to point with particularity you want to point to something in the record or something in the law that the court has overlooked or misapprehended. And in order to do this, I can't recommend it enough. Poring over the Supreme Court's opinion, looking at every line, particularly in the facts that they are finding, to try and determine whether they conflict with what's in the record. Because if you can point to a specific place where they are factually incorrect or inaccurate, and it is the basis for their decision, you have got a hope of getting them to rehear your appeal. If the basis for their decision is something that they've overlooked or misapprehended, that, in my opinion, is the most fertile ground for getting the Supreme Court to rethink what it has written. And once you submit your petition for rehearing, you will be in suspense as to whether or not it will be granted. One short sign that you've got a shot is whether or not the Supreme Court asks the other side to draft a return. If it does not, if you file your petition for rehearing and it sits there just quietly on C-track for months and months, and no one asks for the other side to submit a return, then you can go ahead and be pretty sure that your petition is going to be denied. However, if the Supreme Court is moved by your argument, as surely they will be because you will have written just as John told you to, then they may ask for a return, to which you will then get a reply. And so and once the Supreme Court decides whether or not to rehear your case, they may ask for more briefs, they may ask for another argument, or they may just render a decision that is revised from their previous decision. At which point, that is the end of the line. And but not quite the end of the line, because the Supreme Court will remit the case to the lower court. That could be the Court of Appeals to hear any remaining issues, or it could be the trial court. But if you have prevailed, you can and should file a motion for costs. And Carmen is right, a lot of times this is overlooked, but the Supreme Court has recently upped the amount of money that you can recoup, which it's now $2,500 in attorney's fees, which I think it used to be just $1,000. So that's a significant increase. It is worth filing that. You can also get for your 2,000-page record that the respondent had you designate all kinds of materials that you weren't quite sure should have been included. You can get the cost for producing that record 15 times, or however many copies you had to make for the Supreme Court. So it's worth filing a motion for costs. And again, as Carmen mentioned, it's not just $2,500. If you prevail in the Supreme Court, then you would also be entitled to the costs from the lower court decision. So you could perhaps have a windfall of $5,000, which will more than compensate for the hours and hours and hours that you have spent preparing for that appeal and moving it through the process. Nonetheless, any amount of money is well worth pursuing. And so thank you all for hearing me, and I am now, I think, going to unshare my screen and move on to a panel discussion. Oops. Stop share. There we go.
Thank you, Ainsley. And also at this time, I'm going to launch the second poll.
All right, Marianne, should we go into the panel, or is there some magic with the participation confirmation we need to wait on?
Yep, y'all can just go into the panel.
Great. Well, it says participants can't vote, which doesn't seem right. Um, well, at this point, it's gonna be open season here, and we're gonna have a panel discussion on various topics. And I can see the comment line, so people feel free to submit questions you may have. And I will start the bidding at least with some things to talk about. And the first one I'm interested in what everyone has to say is, whether oral argument in an appeal case makes a significant difference. And what I mean by that is we've heard today, with the exception of Dawes, all the preparation that goes into it. And the Court of Appeals, sometimes we walk into trial courts and we're educating the judge. But typically in my experience, when I step up to a lectern, everyone on the bench knows the case very, very well. And there are people working on it and they know it. And I have often wondered if it really made a difference that they ask questions and so on, if it really makes a difference, a significant difference to the outcome of the case and how you would know one way or the other. So I will pose that question and open it up for thoughts from the panel.
So Ian, as it turned out, I asked that exact question recently to a retired South Carolina Supreme Court justice that I was arbitrating a case with. I asked him that very question. He said that in his time on the Supreme Court, he probably changed his mind 3 or 4 times in an argument, but that doesn't take into account the numerous times when he was undecided going into oral argument. And he allowed us how, despite what we might think, judges do remain open-minded, and that oftentimes when both sides have written persuasive briefs, that he would go into oral argument truly undecided. And that was not at all unusual. And those are the cases where oral argument is probably the most important.
So I suppose the trick would be to decide on the spot at the lectern with your tab notebook which those swing judges are, and to target them to the exclusion of everyone else.
Yes, exactly.
Okay, got it. That's useful. Carmen, what's been your experience on that?
Well, I've always kind of heard, I don't know how much it's true, that you can't necessarily win an oral argument, but you can definitely lose. Like, you could go in and the judges, they're on your side, and then when they're asking you questions and you cannot respond, like I said, you can lose it. I don't know how true that is. That's just kind of one thing they've always said, that, like I said, you may not be able to win it, but you can definitely mess up and lose it. But I do think, especially at the Court of Appeals, sometimes I feel like when I go in that, I don't know how true it is that they have the memo already in the back written with the draft opinion. So I know that, but I still, even if I'm appellant or whatever side, I want to go in and still, like I said, prepare the best I can, think of all those questions that might be the weaknesses of my argument, because that's what I hear judges, they want oral argument. It's not like when you go to the trial court and you're presenting your side, and they really just have questions, and those are, some of them be hypothetical to how this decision, if I rule this way in your favor, what are those bigger implications? So they are concerned about that. And that's what they want the oral argument to be. They don't want it to be you repeating your brief. They really are making that last minute decision on like I said, we talked about how policy can be important at the appellate court. So I don't ever like to say I just want to give up and not think oral argument is important, because it is your last chance to, if they are having concerns, to try to show them why maybe they have concerns if they rule your way, that it might change the course of the law, and you want to relieve their concerns, and that's what you want to focus on at oral argument.
Any other thoughts on that for the moment? Well, a second item that we are often struggling with here at my firm is the law of the case issue that I talked about, and that is when we're getting these rulings from trial judges. You know, do we have to appeal some of those rulings immediately, or do we have till the end of the case? And again, as I indicated, Ainsley Tillman is arguing one to the Supreme Court in December. That's very, very important. And we recently got a ruling that we decided we just had to take up immediately. But I'd be interested in the panel's thoughts on, you know, what kind of things do you feel like you need to appeal immediately, and how do you decide? Because you don't want to get to the end of it and realize that something was the law of the case and you should have taken it up then, and you have a very uncomfortable discussion with your client about it at that moment. So I'd open that up for discussion. John, do y'all confront that over there with the mighty Barnwell, Whaley, Patterson, and Helms, LLP?
Yeah, you know, one thing I've noticed is that in a lot of preliminary motions, the proposed orders we're getting from the other side when we're on the losing end, try to insert things that are beyond the scope of what the judge is supposed to be doing. I just had a motion to dismiss a jurisdictional motion that was denied, and the proposed order was almost making findings of fact or suggesting that we were waiving certain arguments. And that's where I'm most concerned. And what's been effective for me is when those proposed orders are submitted, that's one thing that I found trial judges have been receptive to considering are, you know, if you suggest that the order that's being proposed has language that might go beyond just what the current issue is, and may, you know, conceivably set the law of the case, they're very receptive to that. And I've been pretty successful in just, you know, when the proposed order circulated, emailing the trial judge and explaining, look, you know, we get that our motion to dismiss should be denied, but we don't want to, you know, do anything that's going to prejudice our ability to argue this later on. And if that fails, and normally at the very least they'll do something to, you know, just say that, you know, this is limited to this issue rather than you know, rather than being a final determination.
And Ian, I would add to that. Of course, the premise of the question is not all interlocutory orders are appealable immediately anyway. You know, there's a rule 54 or something that says basically that any order that resolves fewer than all issues with regard to fewer than all parties remains subject to revision at any time. And that prevents most orders from being immediately appealable. And when in doubt, you have to read the statute on what's appealable, because it's kind of, in my opinion, it's kind of a hodgepodge of things that are and are not appealable. But once you get an order that is appealable, then I think what you're addressing is, then do you have to appeal everything else that you didn't like at the same time? And, you know, my advice would be to err on the side of caution, because I've been burned by the law of the case where you get a case to the Supreme Court and they said, well, you know, we agree with you on this, that, and that, but you didn't appeal that issue, or you didn't contest that issue. Well, we didn't contest that issue because it didn't seem important if we won on the other points. So you can't take it for granted. I would be very liberal in appealing other issues once you've got something that's going up on appeal. Of course, you have to be aggrieved. You have to be an aggrieved party to appeal.
Yeah, we've become a big fan of Form 4 denials at my firm, so we don't run it. What are your thoughts on that, Ms. Tillman?
I was going to say, I do like a good Form 4 sometimes, but if you are ever asked to draft a proposed order, I like to do exactly what John is talking about within the bounds of reason, and also within the record. But I like to go ahead and put in findings of fact and findings of law within the proposed order that I think will help our case going forward, so long as they were argued to the judge before. And, you know, that said, that's my response.
Yeah. I like Form 4s too. As John knows, I'm not a big fan of 12B6 motions to dismiss, primarily because as a defense, you usually lose and the other guy gets to write the order and he'll put findings in there, or she'll put findings in there that'll haunt you for the rest of the case. So I'm a big believer. If you're going to lose the case, just tell the judge, just give us a Form 4 order if you can.
Yeah,
Not all can. You know, of course, to preserve the record, you've got to require the court to rule on everything.
I just want to remind people, just in talking about law of the case, I always like to remind people about that 2-issue rule. And so if you are appellant and you are appealing maybe the grant of a motion for summary judgment, you really need to go through and read that order and determine all the grounds that trial court has granted summary judgment. Because if you just appeal 2 of them, but really there was somewhere else in there a 3rd ground, you know, you may be out because the Court of Appeals will say, okay, well, you didn't appeal this other ground that he granted summary judgment on. And that's kind of tied to law of the case. But, and again, that happens sometimes with jury verdicts. I think the most common is the plaintiff loses a negligence case. They appeal that the jury's finding that there was no negligence, but the jury also found no proximate cause, and the plaintiff doesn't appeal that part. And again, that can catch you up as appellant if you don't go through and look at every single possible supporting ground, you know, that's in the order or in the jury verdict, and don't appeal it. You're gonna get caught up in that kind of law of the case 2-issue rule. So just don't forget about the 2-issue rule.
And part of that is the additional sustaining grounds as well, because I've seen plenty of appellants get blindsided by that, something that they didn't even think was an issue. The court affirms it on some other ground.
Yeah, when you're the respondent, I always like to take a second look at whether there's anything else that we could use that we hadn't thought of before, or any additional research. It's always a good opportunity to try to find something.
I think you've used that against me, John.
I would never.
I hope so.
Any other thoughts on that topic from the panel? Another question I often have is techniques for, like, actual techniques for preserving issues on appeal. Because as I said in part 1, there are few things more frustrating than appealing something and being told that you didn't jot or tittle something on it. And my personal preference is I will actually say on the record, for purposes of appeal, I want to make sure this has been denied and preserved. Not that that always wins the day, but I don't know, it's just something I do. Dawes, John, y'all are in trial a lot. Do y'all have any specific things that y'all prefer to do just to make sure it's there if you need it?
I'm thinking more of the summary judgment stage, but you have to be very judicious in the use of 59E motions. If you make arguments that the trial judge does not rule on, you need to make sure that you pass the judge to get a ruling on it, or at least that you ask for it and insist on it. I've seen several times where there are multiple arguments. The summary judgment order addressed only 1 or 2 of them. The Court of Appeal said, "I'm sorry, you didn't file your Rule 59E motion. You can't argue it now." So that's something I'm always, I think, cognizant of. You know, especially in cases where you've got, you know, a whole bunch of arguments, and the trial court doesn't necessarily always address all. Sometimes they're trying to avoid some of those arguments. You need to be insistent to make sure that they do rule on them.
I agonize over directed verdict motions, making sure that we've at least mentioned every possible ground. And as a defense lawyer, you know, you move for directed verdict at the close of the plaintiff's case, but you can't just blanketly reincorporate that in your end of the trial. You've got to redo all of the same grounds and whatever new grounds you might have at the end of the case. So I agonize over that for fear that I'm going to leave some ground out, and then you can't appeal it if you didn't raise it in a directed verdict motion.
Yeah, and Dawes and I before have used written memorandum in support of directed verdict motions, just to make sure you've got everything written down, that you don't accidentally neglect something. Always having it in writing is helpful.
Yeah.
There's a frustration on appeal where you're going through the Court of Appeals and then maybe the Supreme Court, and something has taken on a life of its own that really no one identified in the trial or the court below, and suddenly it's all that everyone's focused on, and suddenly you're fighting for your life on issue preservation on something that did not seem important, and as unappetizing as it is, having been through that fight and maybe going through some of them right now. I've become a proponent of putting everything into the answer and into the briefs, because the trial judge on the other side may get irritated, but suddenly, 3.5, 4 years later, that paragraph is all anyone is looking at on the Court of Appeals. Did you preserve it? We're not going to talk about it if you didn't preserve it. So my affirmative defenses, et cetera, have gotten, unfortunately, even more extensive, but it's only through hard lessons on appeal that I've done that. It may not be important to the trial judge at that moment, but it becomes real important to the appellate court years later, whether or not you preserved whatever that is.
Well, and along those lines, Ian, when I am drafting a motion to reconsider or something along those lines, or really any written submission to the trial court, I take it extremely seriously. Don't just jot it off, and make it very thorough. So my petitions or my motions to reconsider are almost appellate briefs. I like to make sure because it is a precursor to an appeal. And so when you're drafting to the trial court your motion to reconsider, think about, what am I going to be appealing one day? And include it in as issues in your motion to reconsider, just to be sure that it is preserved.
I was just going to mention, I did do criminal appeals for a couple of years. So I read, I don't know, a couple hundred transcripts. And these were just common things that I would see happen at trial that would not preserve the issue. First, you'd have, with motions in limine, like pre-trial, you'd have all this argument. Maybe the state or the plaintiff want to put in a piece of evidence. The defense doesn't want it in. They argue about it. The judge at the end, he says, I think I'll probably let that in. So you get to the trial, plaintiff puts it in, and the defense, they aren't thinking about it. They don't object again, but you get up to the appellate court and they're saying you didn't preserve that because you didn't have a contemporaneous objection when the evidence came in. The only time you might not need that contemporaneous objection is when the trial judge makes it clear that he's ruling and you don't need to object again. But when he's just saying, I probably won't let that in, that's not going to be sufficient. So that was a common one. The other common one, especially that came up in criminal trials, is a motion for mistrial. A lot of times in criminal trials, somehow the solicitor would get a witness to say something. It might let the jury know that defendant was convicted of a similar crime and they was not supposed to come in. You move for the mistrial, and then the judge says, "Okay, jury, just don't listen to that," and trial goes on. You've lost the right to appeal that mistrial because you didn't then object to the curative instruction, and that would happen all the time. And then the other thing I have seen, it's gone with, and this is, civil trials, they move for the directed verdict, the defense, but then at the close of the defense case, they forget to renew that. And so then when it comes to try to appeal the judgment notwithstanding the verdict, because it wasn't carried all the way through, then you lose that opportunity to appeal then. So it's good to kind of maybe just have a brief checklist of things you need to make sure at certain stages what you need to object to and when, and those are just easy. And I know it's just because in the midst of trial, you're just forgetting about all those little things, or you think the judge has already ruled, but those can lose those issues for you on appeal easily.
I mean, I agree with that. One thing that I always am struck with trials, motions, whatever, is how messy it is. You know, you'd like it to be nice and clean. And summary judgment motion and granting it in writing is nice and clean for at least issue preservation purposes. But when you're going back in chambers and you're taking breaks and you're having these arguments over this, that, and the other, and the court reporter is taking it all down, it gets very messy, and you think it was denied and preserved and so on, but a court of appeals reading it years later on the cold record may see it very, very differently. So I don't know that I always do it, but I always try to keep that very clearly in my mind. I need to put a pin in this on the transcript, because looking backwards, the transcript is all that matters. You know, that on the appeal, that it's not, you know, all the intangible signals you're getting from the judge do not come through on the transcript. So even if they don't want you to renew the objection or whatever it is, it's just critical that it be in black and white on the paper.
And that reminds me.
Go ahead.
I was just gonna say, if you have an off the record conference and the judge makes a ruling and that, get it on the transcript.
Yeah, that's what I was going to say. It happens all the time. The judge will take you back to chambers to
Right.
go over the request to charge, and he'll say, I'm gonna do this one, that one, that one. I'm not gonna do that one, that one. You've got to put it on the record when you get back out there.
And there's a human inclination for that, because you're really working together. By the end of a multi-day trial, you and the other side and the judge are kind of working together to try to move this endeavor forward in whatever way. So there's a human inclination that we all understand what's going to happen. The Court of Appeals is not in on that human inclination years later. So just remember that.
That's why I always find the jury charges are kind of an area where you're especially fraught with danger, because the jury, the judge, everybody, maybe a week-long trial, they just want to get this thing over with. And that's, sometimes it's hard, but you still need to go through what you need to do to preserve the issues. And the judge may not like it. You have to decide whether it's worth, waiving an issue, potentially waiving an issue for appeal.
Yeah, the judge may be irritated at you at that moment for more words, but your client's going to be even more irritated with you, 3 years or however many years later after they paid you to appeal, and suddenly the transcript is not precisely what you wished it was.
Right.
All right, well, we are at time under my thing. I don't see any questions in the chat. We're actually 40 seconds under, but maybe Marianne will take us out and get us over the finish line from CLE points of view. And I would just like to thank all the panelists. They took time out of their day, they prepared, they were very patient with me in getting this together, and we should all be thankful to them for keeping the high quality of the South Carolina and the Charleston bar.